A very good evening to one and all present here. On behalf of Dr. AIT family, myself Veena A, Assistant Professor, Department of Computer Science and Engineering, welcome you all for today's webinar. Today, we are presenting a webinar on Effectively Protecting Innovations in India, a smart way to reform education sector in association with Indian Society for Technical Education and Institutions Innovation Council, to be delivered by Ms. Bhavna Sharma ma'am. A hearty welcome to our respected principal, Dr. M. Meenakshi ma'am, for this webinar. A warm welcome to Dr. Gauri Shankar sir, our beloved Dean, Industry Institute Interaction and Professor, Department of Computer Science and Engineering, who is always supportive and a driving force for this webinar. I would also like to take this opportunity to express a hearty welcome on my behalf and on our institute's behalf to Honorable Ms. Bhavna Sharma, Head Patents and Design Intellectual Property Rights, Singhania and Partners LLP, New Delhi, India, for honoring our invitation to be today's speaker. I also welcome all the participants for this webinar. I now request our Honorable Principal Dr. Meenakshi M. Ma'am to deliver the welcome note and to address the participants of today's webinar and to give her valuable inputs. Over to you, ma'am. Thank you. Yes, ma'am. Over to you, ma'am. You can start, ma'am.
Yeah, thank you. Good afternoon to all, and once again I welcome you all for today's webinar organized by the Dean III. This is related to bring the awareness on intellectual property rights. So in this occasion, first of all, I would like to thank the organizers for inviting me to be the part of this particular webinar. And again, I would like to extend the warm welcome to the resource person, Ms. Bhavna Sharma, Head Patents Design, Intellectual Property Rights, New Delhi. And also I welcome all the participants, faculty and the students of the institution for this webinar. As all of us are aware that in the current scenario, to meet the global challenges of education sector, apart from teaching learning activities, an educational institution needs to encourage creativity, research, and to provide a conducive environment. A booming research and innovation teaching approach necessitates IPR, which plays a vital role in providing a competitive edge for the institution. I hope this webinar is aimed to create first-level IPR awareness among the teachers and young intellectuals about the beneficial aspects of patenting their creative and novel ideas, inventions, etc. Such awareness would in turn be highly essential for the promotion of creativity, research, and technological advancements. I hope the objectives of the webinar is to create an awareness about IPR among the faculty and students, and also to educate faculty about the procedure of patent filing. Maybe this is the first level of webinar. I expect many more such webinars from the organizers, the Dean III, to take this particular activity to the next level. With this, I hope all the participants will make the most use of this particular webinar. And I thank you again, and over to Veena.
Thank you for addressing the participants, ma'am. Now I request Dr. Gauri Shankar sir, Dean, III and Professor, Department of Computer Science and Engineering, to introduce today's speaker, Ms. Bhavna Sharma, Head Patents and Design, Intellectual Property Rights, Singhania and Partners LLP, New Delhi, India. Over to you, sir.
Thank you very much, ma'am. And it's an honor to introduce Bhavna ma'am. So Bhavna ma'am has been practicing in the field of patents and design for over 11 years and has expertise in technical drafting proceedings before the intellectual property office and enforcing the patent and design rights across multiple jurisdictions. She advises clients on IP due diligence and audits as well. She is a qualified patent agent and an advocate. She handles a wide range of technologies, including biomedical devices, biochemical, pharmaceuticals, life sciences, chemical sciences, biotechnology, healthcare, mechanical, and clean energy. She strongly focuses on the business needs of the clients, and the clients extol her for providing legal solutions with the due emphasis on practical and commercial aspects. Her clients include the most esteemed universities and companies, R&D centers, MSCMEs, startups, and also individual innovators, designers, and well-known designer, luxury, and lifestyle brands. She's also passionate about disseminating and sensitizing IP awareness among R&D-based industries and students. Various forums have invited her, to name a few: FITT, IIT, CIPAM, CII, NSC Delhi, MHRD, JNU, UBM, IP Pharma, DIT University, and they have all invited her as a speaker or panelist. So we again welcome you, ma'am. Thank you very much. Over to you, ma'am.
Thank you, sir. Taking our day further, I will hand over the session to Ms. Bhavna Sharma, ma'am, for today's webinar. Over to you, ma'am.
Good afternoon, Veena ma'am, Gauri Shankar sir, principal ma'am, and all dear friends who are here and wanting to be the part of this particular session, which is on the IP awareness. And I thank you all, first of all. I would not take much of the time, and I'll just share my presentation with you all. And we are trying to create it a more interactive session rather than a class lecture kind of a thing, which mostly the students are not much interested to take. So it's better that we should create it an interactive session, and in between we can have queries if anyone wants to take those queries. Let me just share my screen with you all. Is it visible, my presentation?
Yes, ma'am. Yes, ma'am.
Okay. So the most interesting part of this particular session is that the topic of it. It is, we are not just focusing on how to protect the IP, but we are focusing on how to protect our IP, particularly the innovations, and then reforming the education sector. In this particular webinar, I'll cover what is the scope of IP. We will briefly discuss about what are actually the IPs mainly available. What are the major challenges that the university, educational institute, or the startups has to face? And what is the procedure and how effectively we can protect? What are the requisite forms that we have to submit? What is the entire procedure included in the protection of a patent particularly, okay? Because the innovations is covered under the patent side. So we are more on the technological aspects, okay? So let us start with it. I hope everyone agree with me that today is a time to create a knowledge economy rather than creating a conventional way of economy. In the previous time, if you all know that we used to much relying on the material aspects or on the tangible assets. But in the present time, it is important that we should use our intellect, we should use the knowledge that we do have, and then create assets out of it. This is the main aspect through which we can stand out ourselves among the gamut of the people among a lot of other people, right? You might have definitely read in the national dailies, in a lot of other articles, that there are a lot of big Fortune 500 companies or the esteemed companies who are focusing much on their protection of the IP, and they have a dedicated management for creating such kind of assets for the company. So these, particularly if I talk about IP, is a asset. Okay, we will see how it actually a asset to us. So, and this is the present. In the present time, I always emphasize that if you create anything, if you have anything, something, anything in your brains, and if you want to actually reform it into something substantive, please do look into the IP side of it. Okay, so in that way you will be able to create an knowledge asset for yourself. And this knowledge asset cannot be created when you are in a job, but it can be created when you are studying, when you are into your classes, when you are doing your research projects, when you are into your PhDs or the postdocs. Okay, so this can help both who are into the jobs as well and who are into the studying aspects as well. So, so it's an important time, and it's an important need that we should focus on creating knowledge economy instead of the other tangible assets only. Further, if we go, we have to understand actually what is IP, and which is very important to know that. You remember I have just put this particular photograph of a phone. It's a telecommunication device, and this device, who are of my age or elder to me must be knowing that this kind of a telecommunication or a phone used to come into at our homes. Okay, and we used to talk through these. But later on, as the time changed, this particular technology has changed to a mobile phone, into a 6-inch or less than that device. So this is creating this is kind of an evolution of a technology, from a phone to a mobile phone, from a static phone to a mobile phone, a portable phone. So whenever we are actually, if I talk about this phone is not just having a technology in it. It has other aspects of the IP are also involved into it. If we can see that if we are talking about the technology, then it would be patents. If we are talking about the aesthetics and the look and feel of this particular device, then there are the designs. If I go and buy, or if I am an entrepreneur who is selling this particular device with a specific name, then it's a trademark. And the manual which is associated with this particular device, which makes the customer aware how to use this particular mobile phone or a device, then it comes under the copyright. Mostly what I have seen in my particular aspect, and definitely because you all are dealing with the technological aspects, your institution is more focused on the technology. So whenever a technology person comes in, or any kind of an entrepreneur who comes to us, they always have, I have a technology, please get it patented. Now, but in order to decide what IP they can protect, what kind of a bundle of a IP they can protect out of one single device, they have to know this actually. Otherwise, what will happen? They will just focus on the patenting aspect of it. I will explain you patent in a very elaborate manner, but I wanted to know you that yes, there are the other IPs also which are actually existing in the same device or a product or a process. Okay, so so they come to us, then we have to tell them, no, it's not just the technology aspect which you have to focus on, but you have to focus on the aesthetics of it also, because See, why the aesthetics is also important, because whenever every customer is not that technology savvy, I think most of us, when we go to the market, we focus on, oh, wow, it looks so great. Okay. Then the second part comes in, the technology aspects later. And we also go by the manufacturing company or the company. If I say, oh, wow, this is an Apple phone, it looks so nice. So these are the two main things. That's the trademark, and the design will come very first to us. So that's why whenever you are looking for any kind of a technology aspect, any kind of a product or a process, please always identify what all other type of the IPs that you can protect within that particular product itself. Okay. The next comes in that now we know that yes, there are the different type of the IPs also exist apart from the patents. So we will move forward, and when now we will be on our main topic, and it would be very interesting in the first hand to see and know that there are a lot of educational institutes who are filing their patent applications, and they are the numbers or the educational institutes over here: the IT Delhi, Chandigarh University, Shaolin University, MIT, SRM Institute, Chandigarh Group. They all are among the top filer institutes in the patent side. And in the sector of the universities and the educational institutes, they focus a lot on all these aspects. They are not just focusing on creating R&Ds within their labs, but they are focusing more on creating IP, particularly a patent out of whatever the students are doing in their labs. There are a lot of other benefits associated with it when they do such kind of activities, and I will discuss what are actually the benefits out of creating such kind of IPs, and how they can use it as a tool for themselves. Okay, so these are the topmost educational institutes into IP filings, and even see, there are a few of the institutes we regularly visit, I think, and the IIT, and I have seen the Galkotias University. So it was very great to know that they have such a vision towards creating patents. So you can be one of them also, and can be ranked. And but the approach towards it, a vision towards it, is actually required, and nothing more, I tell you. So you might take certain inspiration from these universities as well, and look into what kind of portfolios they are creating for themselves, and what kind of SOPs that they are following, and so that AIT can also work upon that. Yes, I do understand, and even I visited your website very thoroughly, and I know that there are a lot of cells within your universities who are promoting the IP. They are facilitating the education startups as well, and so that is a very appreciating step the AIT is taking in the current times. And but for a reference, you can definitely go to the website of these institutes to further know about what their approaches are towards the patent filings in India. Further, it is going to be a very important thing. What are exactly the major concerns? Why the universities or educational institutes or startups or the small scale industries are not able to create that remarkable change when it comes to filing of IP? So there can be a lot of concerns, and we will discuss each concern one by one. And we can segregate these concerns or the major challenging areas into publication, finances and fundings, government support, IP awareness, IP policies and SOPs, planning and strategy, IP management, legal issues. So we should know what happens. I tell you, because IP or a patent is not a task which is going to end in just few minutes or few days. It is a long process. So we should be aware of each of the challenge which will come in our way and how we have to mitigate those risks and the challenges at a right time. Till the time we are not aware of those challenges, it would be very difficult for us to identify those things. So it is better we should be prepared first rather than preparing ourselves at the 11th hour. So I can see these are the major challenges which I have identified while working with the small scale industries or the startups or the educational institutes. I know that educational institutes has a lot of potential to give a lot of IPs from the India and take India to a different heights and create IPs for themselves as well. But now we will discuss the challenges one by one. First is the publication. What happens, and mostly you also have observed this, particularly I'm talking to the students who are here. So might be their teachers or their lecturers, they might force them and say them, you must have a publication, like 3 or 4 or 5 Indian publications or 5 or 6 international publications in this particular year. I feel that, or I believe that a very less of the lecturer, professors or academicians, they focus on and they promote their students by saying that, no, I want you to have at least 2 to 3 patents in a year. So we have a approach or a vision towards having publications instead of having patent applications. So we have to change this approach. And if we see the data which is therein, we can see that India is among the third most scientific publication among the countries who have the scientific publication. India is at the 3rd position. If we can see the growth rate of the scientific publications was 2000, it was 8.4, and now it has tremendously increased also. So we have to change our focus towards it. Why I am focusing on the publication part, I'll let you know later on. When we will actually study what the patents are, you will get to know why I am emphasizing so much on this particular aspect, publications. Please, for the patent, if you have any kind of a technology, before publishing it in any form, anywhere, in an oral, written, exhibitions, please file a patent application first, then go for a publication. Change this particular scenario. Change and deviate yourself for filing a patent application first and then going for the publication. And there is a big reason behind it. So the next comes the finances and the funding. If we see, the India has tripled their funding from the 2008 to 2018 with respect to the global domestic R&D. If we talk about in terms of finances and the fundings for the research, but even if we have increased our approach towards the R&D, we are not able to give that number of a patent application which we that should be actually okay. And if we see, the USA is among the topmost in the GDRD, but the number of the patent, if we give a kind of a statistical view to it, we can see that they are among the topmost filers in the patent application. So they have a focus on creating a R&D and then converting those R&D into the patents. So we have to also go by that approach, which is little lacking in the present time. The next comes in the government support. Yes, these days the government is taking a lot of putting a lot of efforts into creating IP out of the educational institute, SMEs, startups. But the main concern is that they need to have awareness about what kind of a support that the government is giving to them and how they can avail those supports. So, and even I appreciate that the government has recently reduced the fee for the educational institutes as well. So, which is a commendable step, because in India there are a lot of educational institutes are there who are focusing themselves on the R&D. But in the earlier time, the fee for filing a patent was so high for them. So possibly because of that reason, they were not able to take those steps, which now they will be able to take the steps, because in the present time, the fee is reduced to around 80%. So which is a big discount waiver actually for them. There are the startup facilitators program are also going on, and if you have I know that you have a startup cell as well in your institute, so you can avail those facilities as well. In this particular startup facilitator program, the startup has to just bear the official fee and the professional fee of any of a lawyer or a patent agent who are going to work or who are actually designated as a facilitator will get their the fixed professional fee from the government. But the awareness towards such kind of a government support is also needed. So you, as a IP cell, it would be kind of a responsibility of yours to keep keep informing the students about this, keep informing the lecturers about it. The second one comes in IP awareness. So a lot of people know that yes, there is an IP, but they don't go for filing an IP, because when we don't know what is the importance for them, and particularly what is the importance of an IP for their businesses, it is very difficult to change their actually mindset. So firstly, we have to actually make them aware what is going to be how the IP will create a remarkable difference in their businesses. So I always say that the IP is always a assured returns, and which is without any terms in the condition. The only condition provided that you need to be IP with you, a granted IP, or which you should actually commercialize. If you commercialize, and if it has a certain potential, definitely it will give you assured returns, and your investments would not go into vain. Thirdly, that whenever in the initial side, when I was discussing that out of a single device, there were a lot of IPs that you can create, and it is essential that you should protect all the IPs within a single product that you have. It means if you have a technology, then a patent. If you have a design and aesthetics for that particular product, it should come under the designs. And if you have any kind of a marketing brand name related to it, please protect the trademark for it. And if you have any kind of a working manual or any copyrightable work, get a copyright done. So in a single product, you should determine the scope of IP, which is mostly lacking. And we just focus on one kind of a IP, and then we lose out on the other kind of IP. So this kind of a IP awareness is also required, and we should keep making aware and sensitize about what all the scope of the IP they have in a single product or a process, whatever we are talking about. The next main thing is that the educational institutes should actually emphasize on creating IP. They should have a focus. And this can be inculcated by creating certain SOPs, which can be circulated among the lecturers, among the PhD guides, or among the research scholars. And they should be aware of that. And they should know that whatever the technology they are going to work with in the future, or for which they are creating a synopsis, it means at a very initial stage, it should have a future related to creating an IP. It should not be an abstract thing, or it should not be a mere R&D. Okay, so the approach should be like that, and we have to actually inculcate such kind of a thought processes, and for that we need to have SOPs, so that the person who is working or the person who is involved mainly into the R&D should not get deviated, and they should have an aim towards it. For that, even the planning and the strategy is also a connected part to it, and the plans that they have, they need to be aligned to the business objectives. So the business objectives of, if I talk about a university, would be creating an IP so that they can commercialize, and even the students get a benefit out of those commercialization aspect. And then later on, the university can market those commercialization in the IP. So this is the business objective for a university. So every business can have a different objectives, and whenever you plan or create an SOPs for the IP in your businesses, then that should be aligned to your business needs actually. So it is also needed that you have to have an awareness. So the awareness is a primary crux of it, and you need to have investment plans for it. You need to have budgets for it beforehand, before starting. Otherwise, why I am emphasizing on this again is because the IP in itself is a expensive affair. Okay, so because there are a lot of stages which comes in, and you have to pay the official fee. At times, the official fee is also so high, and the professional fee might be for certain stages would be high. So you need to have budgets so that you remain within those budgets, and you need not to compromise in the later aspects, okay, in the later future when your IP is rolling across the years. So these are the main concerns. Further, if we go about IP management and the legal issues, yes, the IP management, what happens, this is also one of the part, and this is also a part of actually planning and strategy. So what happens, there are a lot of enterprise which we see, they are aware of IP, they are getting their IPs protected, and particularly if I talk about a technology, so they have a patent for it, and they have, for example, for a single product or the multiple product, they have around 10 patents. What happens, they keep going with all those 10 patents for many years without identifying and without auditing that the technology, technology for which the patent they have is no more of any use, or the technology is obsolete. But they are investing a lot on maintaining those IPs or a patent. So you have to keep a regular audit on your portfolios. Okay, what kind of a patent you have to maintain, or what kind of a patent or a technology you have to not maintain or leave it without putting money into it or paying the renewal fee. Basically, when we go for the IP management, it also helps us to know how the market is actually evolving, and accordingly we can focus on our R&D, okay, and create different kind of technologies or IPs for ourselves, and which are actually important in that present times. The next one comes in the legal issues. Considering a technological person, a person who is into the technology, the most of the people, they don't have much inclination towards the legal issues. So whenever they are talking to the vendors for creating a prototypes or any kind of a communication they are doing with the third party, they don't focus much on the legal issues, or they don't focus much on that there should be a confidentiality or a non-breach agreement with them. So this is important, that whenever you are disclosing your with any of our interested parties, then you should have agreements and the contracts in place. So for that, you need to have a little understanding of IP laws, or you can avail services from any lawyer who is actually aware of IP. So the IP in itself is a very niche practice, and so definitely you should consult the person who are into or a lawyer who is actually practicing IP in itself. So, and additionally, what happens, even though you are creating IP, you are already having an IP, you are aware of IP, but at times you are not able to comply with the statutory deadlines. So that actually results into abandoning of your IP rights. So it is important, if you are already having an IP, you need to follow the statutory deadlines, and also you need to go and fulfill the compliances that which are required. So these can be the major concerns or the challenges the universities, educational institute, or the small scale industries which mainly face. And by setting up this all, they can definitely have they can mitigate their risk which is involved therein. The another concern is the industry linkage. I know that AIT is having industry interaction cell is there, and I just briefly read about it on your website, and herein I'm just discussing what the industry linkage is, and it is a need of ours. And we do see a lot of university and the industry linkages coming in, and this is also one of a challenge. Why do I consider it as a challenge? Whenever you are working into a research and development unit of a university or an educational institute, you are not much into what are the marketing feedbacks or the consumer feedbacks. Okay, so when you are not having such kind of a feedbacks, then you will work on the abstract theories only. So it is important that the universities or the R&D centers of the universities should create an industry linkage. And we can say that there are three different units. One is the industry, institution, and the government. They should work hand in hand. They should not work individually. So what will happen when these three units actually work together? So whenever the institution and the industry comes and collaborate and they associate on certain kind of a technology, then the institution or the students who are in the institution will work upon the real-time problems. They will have they'll have a learning on the real-time issues, rather than working on something which abstract or an absolute thing which has no future after like 5 or 6 years. So it is always best, because the industry is the one who is directly dealing with their products, with the consumers, and getting a feedback or the market research getting done. In that manner, the institutions or the students in the institutions will get benefited. If we talk about what kind of a benefits the industry is going to have, they are not going to, they need not to actually set up a big R&D culture or a big R&D cells within their industries. And in that way, they can cut down a cost on R&D on the infrastructure. Okay, and on the human resource, because they are availing a human resource from the universities themselves. So in this manner, both the institutions and the industries would get benefited. When the institutions, if you see, there are a lot of a grant which the government is giving to the institutions for filing IP. There are a lot of schemes which the government has launched for helping the institutions, women innovators, lot of startups. They are funding their IPs. So in that manner, the government and the institutions both are getting benefited, and the government is giving a ample support to the institutions in this regard. And even at times, the government is giving a lot of legal assistance to them. So these are the main aspects if we talk in terms of the institution. Now come on the what the advantages the industry and the government will have in this particular setup. The government has the employment will be created by the industry. There might be a tax benefits to the industry because the industry is directly working with the institutions. They are giving money back. So this kind of a setup can be created, and it also helps them. It's an ease of doing business. So such kind of setups are very much required in the present time, and the university industry linkage can be a best example. So, and it's very important as well in the present time. And there are, yes, a lot of the institutions and the industries who are working in associations. And the best example could be, to quote over here, is the ISC Bangalore and the IIT Kharagpur. They have a Wipro Center, and even Samsung has established their digital academy in the IIT Guwahati. So can you believe the students are directly getting collaborated with the universe, with the industries? And can you imagine the profile or the CV or a resume the student will have after working with such kind of industries? And the job prospects for those students who are working on the project of such industries would be much higher. So such in fact, the universities can, in fact, your university can have a collaboration with a lot of such kind of industries. And yes, the industries are also very much interested into investing into the educational institutes. Further knowing your patent. So now you will get to know why I was emphasizing a lot when I was talking about the major concerns on the particular part, which is the publication. So the story will be revealed over here, what was actually the crux of it. So now we have to know actually what is a patent. How do I define a patent actually? Patent is nothing. It's actually an exclusive right. It is a monopoly actually. Monopoly for what? Monopoly for to make, use, sell, or import an invention for which you have actually gained a right, or for which a right is granted to you. But when this particular right is granted to me or to any of the innovator, when they disclose their invention to the Indian Patent Office, and that invention can be a product or process, or it can be a product and process. But that particular invention needs to qualify the registrability criteria. What those criteria are: novelty, inventive step, industrial applicability. So if you see the novelty means newness. We will see what the newness is actually. So, but you have to understand that the patent right, which is granted to a patentee, it's for a fixed period of time, which is 20 years. And it is limited to a jurisdiction in which that patent is granted to you. So this is an entire summary of what is actually a patent, for what it is given, when it is given, what would be the term, and for which jurisdiction the right would be. Okay. So the next comes in the patentability criteria. So I talked about don't publish your applications before you file a patent application. Because if you see, the first criteria which I have written is a novelty and a newness. When a newness is destroyed, when you show it to someone, when you display it, when you publish it, then the newness is entirely destroyed. And that publication can be oral or a written. It could be anything. So that is why, so that this patentability criteria with respect to your invention is maintained, so you have to first file your application instead of putting your applications for the publication with any of a journal. Okay. So if the novelty is destroyed, then you would not get a patent, even though your invention is a remarkable, it's a disruptive invention, right? It's just going to change the entire technical scenario in the future. But if you have lost the novelty, then you have lost one of the patentability criteria, and hence your invention would not be a registrable one. The second aspect comes in the inventive step. The inventive step means a technological advancement over the existing technology, and or having an economic significance. It can be disruptive technologies, or it can be incremental technologies as well. Then you have to show, if you are on a incremental innovations, then you have to show what were the limitations in the previous art and how those limitations you have overcome when you are going to introduce this particular technology. The third criteria is the industrial applicability. It means the invention for which you are filing a patent application can be made or used in the industry. So these are the main criteria for patentability, and we can call them as a patentability criteria: novelty, inventiveness, and the industrial applicability. Now there comes in, if any of an invention which qualify all of these criteria, would that be a patentable subject matter? We have to see no. There is one more particular criteria which are laid down in the Patent Act, which says that there are the certain non-patentable subject matter, even though your invention is qualifying those three criteria which I mentioned before, is the novelty, inventiveness, and the industrial applicability. Even if those inventions are falling in the non-patentable subject matter, they won't be granted a patent for it. So what are these? Any kind of a frivolous invention. For example, if I say, for example, a minute hand, or if an invention which is having 25 hours instead of 24 hours, if I create a watch like this, it's a kind of a frivolous invention. Anything which is contrary to the well-established laws, it is also contrary to the well-established laws. So then that would not be a patentable subject matter. If anything which is contrary to the public order or causes a serious prejudice to the well-being, then definitely it's not a patentable subject matter. For example, if I say I invent a machine which is for causing adulteration, it's not a patentable subject matter, or a method for adultering your spices or whatever. So it's not a patentable subject matter, even though it is qualifying those three criteria which were I discussed before. Even for the scientific principle, any kind of abstract theory or just a discovery of a living or a non-living thing is not a patentable thing. Further, new form of a known substance, new use of a known substance, new process of a known process is not a patentable one. For this particular new form of a known substance or a new use of a known substance, for this particular, you can read about, there is a landmark judgment for this, and it was for the Novartis versus Union of India. In that particular, they have the court, the Supreme Court, Honorable Supreme Court mentioned that, and they opined that if a new form of a known substance is there, then they have to show a remarkable therapeutic efficacy towards it. So if you say that I have a composition which is available and you have created a new form of it, you have, through the experimental studies, you have to show that it has an enhanced therapeutic efficacy. Okay, so you have to give an experimental data in order to support your theory or in order to support your disclosure for this particular section. Further comes in any method of agriculture or horticulture. Any medical procedure or a treatment method is not a patentable subject matter in India per se. So, but yes, for the medical procedure, if someone is talking about a medical device, yes, it is a patentable subject matter. But how that medical device actually going to do a surgery or going to do any kind of a medical procedure would not be a patentable subject matter, but that medical device would be a patentable subject matter. Then the plants and animals as a whole or any part thereof. And because it's very important. The next one is very important for those who are working into computer programming. So there is a specific section for it which says that the mathematical or the business method or the computer program per se are not a patentable subject matter. So you have to give a substantial support towards it, that it's not a computer program per se. There is an involvement of a hardware component, and it's not a abstract theory that you are talking about. So this is a kind of a debatable section of the Indian Patents Act. So you need to be very careful and while drafting your application who are belonging to mathematical or the computer programs. The next one is if anything falls under the copyright or it's a copyrightable subject matter. For example, any kind of a booklet, cinematographic work, or artistic work, this all comes under the copyright. This cannot be patented. Further, any kind of a scheme, rules, mental acts, they all are non-patentable subject matter, even though they qualify the patentability criteria, novelty, inventiveness, and the industrial applicability. The presentation of information is not a patentable subject matter. Integrated circuits also is not a part of the Indian Patents Act. It has a specific act and it is dealt in that particular specific act. So that's why it is it's not cannot be dealt in the Indian Patents Act. Any kind of a traditional knowledge, for example, the use of a haldi for as a medicinal use of a haldi cannot be a patentable subject matter, right? You know that if it's for skin diseases, and if someone identifies that it can cure your hair loss, for example. So, but you know that it treats, it has a certain kind of a traditional knowledge attached to it, so you cannot protect it. And any inventions which are related to the atomic energy are not a patentable subject matter. Such kind of a technologies, if any kind of a patent application is filed which has a role of for example, if I tell you, I was dealing one of a patent application which has used the transition elements, okay? So in those from the periodic table, so those that particular application was dealt separately, and that application was actually referred to the Department of Atomic Energy. Till the time such applications don't get a clearance from the Atomic Energy Department, they won't get a grant. If the Atomic Energy Department says that yes, it is related to atomic energy, the patent office will reject that particular application. So dealing with such kind of application follows a different rule or a way. Further comes in, there can be a certain pre-filing measures what we should look into before filing. So there are the two main aspects. First is the prior art search and the technical drafting. These both parts are very important when you are filing your application. So it is always advisable that whenever you have any kind of a disclosure with you, or you are working on any kind of a technology, or if you have a synopsis with you, it means you have a vision for a certain technology, you can definitely go and conduct a prior art search for yourself. So what is a prior art? First of all, we should know prior art can be any kind of information or a disclosure which is available in the public. It can be oral, it can be written. So whenever you do a prior art search at your end, in your lab, on your Google, then you can search for patented literature, or you need to search also for the non-patented literature. It means and that should be anywhere in the world. If it is, for example, you are sitting in India and you want to work on any of an invention in India, and you see that it has a potential, but that particular invention is already disclosed in USA. So that would create a prior art for your particular application or for your particular innovation. So it is necessary that whenever you are doing a prior art search, you should not limit yourself to a particular jurisdiction only. So how you can do actually the such kind of a searches. There are a lot of unpaid and the paid databases. You can go for unpaid databases, and the best would be for you is the Google patent search. So the way you do your Google search on the Google Chrome, the similar way you can do your search on the Google patents. Okay. So if you type Google patent, it will open a window for yourself, and then you can start searching, and it will disclose all the patented literature for you. So, and it's a user-friendly database, and so that you can be sure at your side. But yes, there are the technical aspects, technical research or the analyst are also there who do professionally such kind of a searches in order so that you are certain that yes, this is going to be a patentable subject matter or not, because if the already a prior art is existing, then your newness is already destroyed. The next comes in the technical drafting. If I tell you, the technical drafting is also one of the major aspects to it, because whenever you file your application with the Indian Patent Office, which is an authority to give you a grant, you have to disclose your entire invention. And the document on which you disclose your invention, we say it is a techno-legal document. There are the two ways of filing it. You can file a provisional application. Provisional application is when you feel that yes, the work that you are doing, it has a potential, and the same way you feel that yes, your competitors might also be working on the same kind of invention. In order to gain a priority over other same or the similar invention or over the competitors, you can file a provisional specification with the patent office, and after 12 months you have to file a complete specification with, it means the complete details of your innovation with the patent office. So what happens when we file a provision, it is actually a way of securing a date for yourself, right? If I file a patent application today and someone is filing a patent application for the same kind of innovation after the 6 months, then I'll have a priority. Okay, that application would be considered that it belongs to me, that particular innovation or a patent application, instead of that person. Okay, so that's why a provision application is filed just to secure a date. But once I file a provisional application, I have to file a complete specification within 12 months from the date of filing of my provisional application. If I don't file my complete application, then my provisional application would have no sanctity and it will not proceed further, and it will be considered as that I have withdrawn that particular or abandoned that particular application. Okay. Now, it is not necessary that you have to always file a provisional and then file a complete. If you consider that, yes, today I have the entire disclosure of my specification, you can directly go for filing a complete specification. There is a one requisite with regard to the complete specification is that it needs to have claims. Claim is a part of your invention or your technical disclosure, which actually decides the periphery of your rights. What kind of a rights you will have on that particular invention. So the claims need to be drafted very carefully. It would be very difficult for you to actually in this particular short time to teach you about this, how the claims are drafted. But I can tell you that this is one of the most important aspect of it. Even though if you're getting your specification drafted by someone else, or if you outsource it, I always suggest that please read your claims very carefully. And the claims need to have a support from your description or the entire disclosure of your specification. Okay, you cannot claim something which is not disclosed in your description part of it. So this is the one thing. These were the main primary aspect actually which I wanted to discuss what kind of measures that you can take before filing your application. Once you are ready, you know that you ascertained by doing a prior art search that yes, your invention has a potential, it is novel, it is inventive, it is qualifying the patentability criteria, and you have drafted your application well, the way it is required as per the statute, then you can submit your application with the Indian Patent Office. Now you are going to file your application with the authority for a grant. So how you can actually file? There are two modes of filing. One is the online mode, one is the physical mode. So, but now these days, the most preferred mode is an online mode because you're going to have a global access It's a 24/7 availability, and it's a paperless way. You need not to submit anything into hard copies with the authority. And definitely there is the official fee benefits associated when you are filing through the online mode. The another thing with the, yes, you can say that I'm not a tech savvy, I'll file it with through the physical mode. You can file it with any one of the branch of the Indian Patent Office is Delhi, Kolkata, Mumbai, and Chennai. But you have to see in which jurisdiction, jurisdiction you are lying with actually. For example, if I'm in Delhi, I have to file with the Delhi Patent Office. If I'm in Punjab, I have to file with the Delhi Patent Office. The same way, you have to look into which will be the right patent office for you as per your jurisdiction and your address for service. Okay. So the next one, the another thing is that whenever you are filing a patent application in a physical mode, you have to give the documents in a paper form to them. And definitely it's an extra burden on you for the printing the papers. And so that's why we always say that it's a preferable mode paperless. And these days we are promoting to be paperless actually. So and another aspect is that whenever you are filing a physical, then you have to, the fee, the applicable fee for the filing would be 10% higher than what is for the online filing. For example, if my filing fee for the online filing is 1,600, when I am filing it through the physical mode, I have to pay a fee of 1,760 rupees. That is 160 rupees higher, which is 10% higher. Additionally, there is also an extra exercise that you have to do. Either you have to have a check with you, or either you have to have a DD for the payments. The another restriction when you are filing it physically is that it's Monday to Friday, 10 to 4 only. Otherwise, when you are filing it online, you can go anytime except in the night hours. There is a one hour window when you cannot file because of this, the bank reconciliation processes and nothing else. So now I have opted for that. Yes, now I want to file my application, and I have chosen the what kind of a mode I have to go with. Now comes in what are the necessary documents that you have to actually place with the patent office. There are the forms that you have to give, which is a form 1, 2, 3, and 5. These are the main basic forms which you have to give. And if you are claiming any kind of a special status, for example, if you are a university, if you are a startup, if you are a small entity, then you have to give evidence towards it. In the case of a university, you can give your establishment document with regard to the university. If you're a startup, then you have to give your DIPP certificate. If you are a small scale industry, you have to give your Udyog Aadhar or the small scale industry registration. When you claim these special status, then you can avail the reduced fee for yourself. If you're not going to give such kind of a support document, then you cannot claim the reduced fee status. If I tell you the fee for an individual small scale industry for these special statuses is 1,600. But if you're not availing these statuses, then you have to pay a fee of 8,000 rupees. So you can see there is a huge difference into the fee structures. Another one is that, yes, the official fee should be accompanied when you are filing your application. There is a request for examination with the patent application. This is a mandatory request, and it is unlike any other IP. If you don't file your request for examination within a stipulated time, within a statutory timeline, then your application would be considered as withdrawn. And the time limit for it is 48 months from the date of your filing of the application. You can also file your request for examination along with your filing of an application as well. So this is a mandatory thing. And once the request for examination is filed, yes, there is one more compliance before going to the request for examination. Again, within 6 months, you have to file a statement and undertaking with the Indian Patent Office, which is disclosing the status of your counterpart applications. It means if you have filed your application in India and within the 6 months, if you have filed your application, say in USA, EPO, or in Japan, you have to give a status of those applications to the Indian Patent Office within the 6 months. If you don't do, definitely the objection would be raised and you have to comply with that by paying an extra amount for a petition. Now coming back to the request for examination. Once you file a request for examination, an examiner is allotted to your application, and or I would say your application is allotted to an examiner, and the examiners are the technical people to evaluate your application in accordance to the laws which are laid down in the Indian Patent Act. And those are the patentability criteria and the non-patentable subject matter, as well as on the other aspects. So now the prosecution starts, and the examination report is issued to you once the examination is complete. And the examination report would include the technical objection, which would be procedural or procedural non-compliances. So you have to comply. For example, you haven't filed the required form the way it was to be, actually, the Form 1, which is an application for grant. So as per the statute, the examiner would direct you to file as per the law. It should be in that format which is prescribed in the law. So this is just for an example. And the examination report would also have technical objections, which would be on the patentability criteria, that your invention is not novel, it's not inventive, it's not having any kind of an industrial applicability. The applicant, the examiner may cite any kind of a prior art into it, the existing inventions, the patented or a non-patented literature. And you have to, it will also include if your invention is lying in any of the sections related to a non-patentable subject matter, which I also discussed with you, like the frivolous invention, new process of a known process, all those. So, and as well as on the unity of invention. Unity of invention means one application for one product or a process. If you disclose two products or processes, then your the controller will raise an objection and they will ask you to divide that application. Okay. So such kind of, even on the scope or a clarity of a claims, the claims are not drafted well. It is not supported by the description that you have provided. Such kind of a technical objections are raised, and you have to file a response within 6 months from the date of issuance of an examination report. Recently, the Patent Office has introduced, the government has actually introduced an amendment, and through that amendment, you can file an application for extension of this time limit. And the maximum extended time limit is 3 months, like after 6 months. That would be, it means in totality, the 9 months, not more than that. So you have to comply with all those objections. You have to give your elaborated reply. And you have to upload it or you have to submit it, whatever the way that you are feeling. And once you file your response with the Patent Office, your application is examined once again based on your response or based on the amendments that you have done in your specification in order to overcome the objections. If the controller is satisfied, they may grant it. If they see that, yes, there is a scope of further clarifications from the inventor or the applicant, they may issue a hearing notice to you. And you have to attend the hearing, and that is going to be an in-person hearing. Now, these days, we are doing it through VC. It's all through the virtual platforms. So we discuss the entire case with the controller, and they give their directions at times. And you have to comply and you have to file your return response once again. If the controller is satisfied with your responses, they may grant your patent. If they don't, they would refuse your patent application. Once the patent is granted, you have to pay the renewal fee. And this is going to be an yearly renewal fee. If you don't pay it, your patent would be lapsed and you are not going to have any right on it. Once there is one more compliance with regard to the Indian patents is that statement of working. That yearly, you have to yearly file a statement of working whether your patent is actually working on a commercial scale in the territory of India or not. So you have to file this particular compliance. You have to submit your statement with regard to it. There is a specific form for it. Now, there is one more thing which I want to discuss before going to our next topic. What are actually the benefits of patent protection? Because I feel that it seems so easy when I was discussing with you, but it is not actually that easy. It has a lot of other intricacies involved to it, and many other aspects, technical aspects, as well as the legal aspects are involved into it. So that's why it is little difficult. So, but why I am taking this much of pain? Why do I put this much of efforts to have a patent or any other IP? There must be a certain benefits attached to it. Then only I am going to put this much of efforts as well as money. So we can assimilate those particular aspects. But before discussing this, I would say one more aspect for protection or for the IP is that there are the certain cases when the patentee, when the applicant or the innovator feels that the jurisdiction of India is not a preferable one for me, because the Indian market is not complied with that particular technology, and they directly want to file their applications outside India without filing in India. Or second scenario, they filed their application in India, but within 6 months from the date of filing of their application, they want to file their application in another jurisdiction as well, claiming a priority from the Indian application. In these two circumstances, the applicant or the innovator has to seek a foreign filing license from the Indian Patent Office. And there is a special which is called, we say it FFL, Foreign Filing License, Foreign Filing Permission. If someone fails to seek such kind of a permission from the Indian Patent Office and they file their application directly in outside jurisdiction, there are certain penalties attached to it. So it is important that you seek a permission from the Indian Patent Office in both of the circumstances which I have discussed with you. Further comes in, now coming back to this particular slide, what are the benefits? So we can sum up all these benefits like this. Firstly, which I talked about, it is going to have an exclusive right for you. Exclusive right, a monopoly to sell that particular technology, market that technology, import that technology. Okay. Secondly, it would give you a market recognition. You might have seen when you go to the market, and there are a lot of products these days. Very basic example, Apple phone. So you know that the Apple is too much into protecting their technology. Samsung is too much into protecting their technology. Qualcomm is too much into protecting their technology. So they are gaining a market recognition for their products. There is a patent or a technology grant attached to it, which is creating altogether a different line for themselves. So in this way, they are creating a market recognition. So this is one of the benefits. You're creating a company asset value for yourself. I told you that this is an asset actually. How it is an asset? What you can do with the asset? You can sell it to someone. You can license it to someone. It's just like your property. What you can do with your property? You can sell your property. You can rent your property. You can lease your property. In the same way, the patent or the IP that you're creating, it is also an asset. And you can sell it, license it, commercialize it the way you want. Okay, you can mortgage it to someone. So that's why the companies are creating a value for themselves and the assets out of this. I talked about you can commercialize in a way that through the license, royalties, through cross licensings, through the other means also by mortgaging, etc. Recoup the investments. When you are commercializing, you will definitely get a monetary benefits out of it. So whatever the investment across the time that you have done on that particular technology, and whatever the investments that you have done on that technology, you will be recoup all those investments when you're gaining something out of it. Okay. Definitely, it reduces the competition. As a technology person, whenever I go into the market or whenever I'm searching for any kind of a technology or any kind of a product, definitely I have an inclination for buying a product which has a patent for it. Okay, so in that manner, all the other products which might be competitive to that particular product or particular technology would not have edge on my opinion, actually, right? So in that manner, you can reduce the entire competition. You can go for the fundraising. A lot of these days, mainly for the startups or the small scale industries, if the investors are coming in and they want to actually invest into your venture, they always look into the potential of IP, creating an IP. Also, they look into how much IP that you have already protected. So in that manner, you can raise a fund, and even you can invite a lot of investors into your startups. The last one would be legal actions. It means if someone is in an unauthorized way is using your inventions, the protected inventions or your patent or a technology which is already protected, you can go and sue them. You can file infringement suits against them, and you can claim damages against them. So these are the main benefits which we can actually sum up when we talk about what I'll get out of protecting my innovations and putting so much money and efforts into it. So I hope this was of us very of some use to you, and you would be able to understand what are the challenges and how we can mitigate those challenges and how we can file patent applications. And if you have any queries, you can definitely write to me, and you can also follow me on LinkedIn with bhavnasharma.itr. So thank you so much.
Thank you very much, ma'am. Veena ma'am, are you there?
Yes, sir. Thank you, ma'am, for knowing us or for telling us what IP is, the major concerns such as IP policy, standard operating procedure, planning and pre-filing measures and filing the patent, and also the benefits of the patent protection. So participants, do you have any queries? Hello? Okay. Okay, so there are no such queries. So we'll just wind it up. So there's an end to everything, but we believe that there is never an end, but always a beginning.
Veena ma'am, hold on for a minute.
There is a query.
Sorry. Yes, sir. Yes, ma'am.
I think there is a query. Nirmala
ma'am. How
yes,
will we
Nirmala,
get to know whether our concept is patentable or not?
See, for this, I told you that you have to do a prior art search first thing, which will ascertain that yes, there is no prior art already existing. It means your invention is new in itself, right? Then you have to know that whenever you search for a prior art, you have to determine that yes, your invention is having a certain kind of a technological advancement over, so that whatever the previous limitations were there, you are able to overcome those limitations. If you qualify those criteria, then definitely you can go for filing a patent application for it. So in that manner, you justify, you ascertain that yes, it's a patentable subject matter for you. How do one can buy intellectual property? Definitely, you can consult with who is actually having a patent or an IP. Like if I'm an IP holder, you can come to me, and then definitely there can be a technology transfer. There can be any kind of a commercialization agreement with them. In that manner, you can buy IP.
Any more queries?
The best part with your institution, which I have found, that you people are working a lot on this, and you have very dedicated cell for it. Not only just a cell, but as far as I got to know through the disclosure which is on their website, on your website, that you are actively working on such aspects. So keep doing it, and keep like motivating students for such aspects, as well as the mentors, so that they can inculcate IP culture within their students and the research scholars.
Sure, ma'am. Sure.
Thank you very much, ma'am, for your kind words.
Yes. If anyone is having any query, I think they can unmute themselves also.
Yes, yes. If you have any queries, dear participants, please unmute yourself and ask. No.
Veena ma'am, you please go ahead.
Yeah, okay. So I now request Professor Srinivasa A.H. sir, Associate Professor, Department of CSC, to propose the vote of thanks. Over to you, sir.
Okay. Thank you, ma'am. Hello, may I audible now?
Yes, sir. Yes, sir.
Okay. So, good evening, dear participants. So, we are at the end of the webinar on effectively protecting innovations in India, a smart way to reform education sector. So, this webinar is a means of disseminate knowledge for those who are interested in filing patents and for protecting intellectual property. So, I'm sure all the participants of this webinar are benefited. Okay, being one of the coordinators of this program, it is my privilege to propose the vote of thanks on this occasion. Dr. M. Meenakshi, ma'am, principal, is a constant inspiration for all the activities in our institution. On behalf of the Dean, Industry Institute Instruction Office, I acknowledge our gratitude to you, ma'am. Dr. M.E. Vijay Kumar, Vice Principal, has given constant support and encouragement. On behalf of the Dean Institute, Industry Institute Instruction Office, I acknowledge our gratitude to you, sir. So Dr. Gauri Shankar, as Dean Industry Institute Instruction, is a catalyst who inspires us to do our best, and we acknowledge the gratitude he has extended to all of us. We have been fortunate to be supported by a team of active and dedicated coordinators who are well versed in their jobs. My colleagues, Ms. Ashani KP, Ms. Veena A, Dr. Tanuja P, and Mr. Pravina MV, have worked hard in making this event a success. Thank you all. So I also appreciate the efforts of our resource person, Ms. BHAWNA Sharma, who delivered an outstanding session on how to effectively protect innovations, which goes a long way in reforming the education sector. Thank you, ma'am. So with these few words, let me conclude my speech. Thank you, one and all.
I once again thank all the participants for attending today's webinar. Thank you all. Thank you, ma'am.
Thank you very much, ma'am.
Thank you.
Thank you, ma'am.
Thank you, sir. Thank you. Bye. Thank you so much.
Bye.
Bye, sir.
Bye.